This is English shorthand dictation number 154 and the dictation speed is 140 words per minute. Ready? Start. The Hall of Justice operates solely based on pieces of evidence and allows no opportunity for biases in its working. However, according to sources, 6% of the convictions are false. A significant reason for this could be the inclinations caused by humans while assessing these attestations. There are a lot of theories which suggest the replacement of human judges by robots. They are also upheld by the unvarnished truth that machines would make evidence-based verdicts rather than subjective. On the contrary, critics challenge the ethicality of artificially intelligent robots and believe that its introduction in courtrooms could be disastrous. We have to discuss the applications of artificial intelligence in the judicial system of India, the proper way of introducing it, and the shortcomings and the advantages of it. Currently, the Supreme Court of India is using artificial intelligence for translating its judgments into several vernacular languages for a mobile application. However, the Chief Justice of India is fascinated by artificial intelligence and believes that it could be of significant use in the judicial system. He thinks artificial intelligence can prevent the delay in the delivery of justice by working on the repetitive, mathematical and mechanical parts of the judgments. Regardless of the serviceability offered by artificial intelligence, the Chief Justice of India made it explicit that artificial intelligence will not replace human discretion. He claimed that artificial intelligence can only aid the proceedings but cannot take important decisions. We know that the government of India is interested in the deployment of artificial intelligence in the judiciary, but let us understand how they can be installed in the judiciary of the world's largest democracy. Artificial intelligence, like in numerous other fields, has made its entry into the courtrooms. The correctional offender management profiling for alternative sanctions is a practical example of artificial intelligence in use. The criminal judges of some states use this to predict the defendant's likelihood to offend. This technique provides a score from 1 to 10 to the defendants on 137 factors like gender and past criminal records. However, the accuracy of this technique can be questioned as it is prone to machine biases while dealing with white and black Americans. Likewise, India can also make use of artificial intelligence in judiciary besides merely translating verdicts. One application of artificial intelligence in the Indian courtrooms could be the replacement of traditional court reporters. These reporters need to hear different types of court proceedings and make their respective transcripts. However, the hectic job leads to typing errors in some transcripts. Advanced voice recognition softwares can write error-free transcripts very rapidly and save a lot of time in the courtroom. Artificial intelligence can provide its contribution to the judicial process by playing an advisory role. It can help in assessing the facts and thereby providing a statement for the judge to consider. Artificial intelligence can draw data from previous cases, as mentioned by the Chief Justice of India, and reduce the human task of reading different laws. Emotionally intelligent robots can be present in the court to report facial expressions and body language of the accused in criminal cases. The judge would still have the power to determine whether to consider the statement or to deny it altogether. From the previous example of offender management profiling, it can be ascertained that artificial intelligence softwares are still not very accurate in passing predetermined judgments. If artificial intelligence is given the power to pass the final verdict unanimously, many innocent people would be punished, even for a crime that they are unlikely to do. There would be no hope for mercy, as machines will not work on emotions. Artificial intelligence would penalize people based on their past and current records. This would not allow future improvement in an individual's mindset. Artificial intelligence programs are computers, after all, which work on a given code. This leaves room for immoral manipulations. Now imagine the supreme judicial power and the decision of a person's life rest with artificial intelligence softwares. It would be a catastrophe. Considering the probability that artificial intelligence will pose a fundamental threat of autonomy, it needs to have some sort of human intervention. There has to be a system to ensure that the goals of artificial intelligence coincide with human goals. The idea behind this is to safeguard the final power of decision making with humans. Our Constitution delineates both the powers and responsibilities of institutions and those who govern them. This institutional edifice must be protected. If not, those manning the institutions by their actions are likely to cater to their enervation and eventual decimation. Today, we are seeing that happening before our eyes. We are ourselves to blame for not raising our voice and calling to attention the malaise that has set in. Our fundamental rights are set out in Part 3 of the Constitution. Under certain circumstances, they are subject to legislative curtailment. Equally before the law is a fundamental constitutional premise prohibiting discrimination on grounds of race, caste, creed, religion, place of birth, and sex, subject to the caveat that the disadvantaged may be empowered by acts of positive discrimination. Other rights fundamental to our existence include freedom of speech, freedom to form associations, to move throughout the territory of India, along with the right to carry on any profession, trade, or business, are subject to regulation. They need to be protected from unreasonable legislative and executive interference. Today, our lament is that constitutional courts obliged to uphold these rights have, in recent years, often been lethargic and occasionally remiss in protecting citizens from legislative and executive excesses. Any matter before the court, apart from pure personal inter-party disputes, involves individuals and the state. We can assume that in that equation, the state represents power and the aggrieved individual is relatively powerless. In this context, the largest litigant in this country is the state, as also the most powerful. The role of a court in deciding such disputes must not just be stated, but assessed in the context of its performance in recent years. There is no point in having a judiciary in which the judges do not have a liberal mindset. A judge with a conservative disposition is acceptable, but not an illiberal judge. Such a judge should not find a place, at least in our constitutional courts. A judge with a statist mindset ends up helping the powerful and failing to protect the weak. This does not mean that individuals should be protected despite their open flouting of the law. It only means that courts should scrutinize the exercise of power by the state on the touchstone of reasonableness, and that the extent of its exercise of power is proportionate to the outcome sought to be achieved. The court must not allow it to be misused to cripple individual freedoms. A judge who accepts statements by the state without adequate scrutiny does a disservice to his oath of office. The actions of the powerful must be scrutinized to ensure compliance with laws that are reasonable. An unreasonable law upheld by the court itself amounts to denigrating the freedoms we cherish. Laws that presume the guilt of a person, that unfairly shift the burden of proof, that prohibit the grant of bail unless the court believes the person prosecuted is innocent, are laws that are ex facie unreasonable. They need to be scrutinized. Executive actions misusing provisions of the Unlawful Activities Prevention Act to target students and those who agitate against government policies should be frowned upon. The constitutionality of laws and actions to prosecute for sedition our young who have no means or power to overthrow the established government needs to be adjudicated without delay. Such laws are being openly misused. How else can one justify the existence of constitutional courts which are obliged to protect the freedoms that we cherish? Constitutional lethargy witnessed in recent years in not deciding matters of great moment with alacrity is another matter of concern. Petitions challenging the demonetization decision have not been taken up till date. The challenge to the constitutional validity of electoral bonds through which political parties are funded is lying in slumber. The absence of its constitutional scrutiny, in fact, changes equations of power in a democracy threatened by an oligarchic setup. The decision of enforcing a sudden lockdown without adequate notice in response to the outbreak of the COVID-19 pandemic left millions of helpless migrants stranded.